Good evening, everybody. Welcome back for another edition of Reasonable Doubt. I'm your host, Jimmy Ardwan, and unfortunately, my co-host, he's not here tonight. He's out, I don't know, he had prior commitments, is what he said. We'll forgive him for this time, but in his place, I have two really great guests returning to the show. My good friend, Dane Ball. Dane, welcome back.
Thanks for having me.
Glad to have you here.
It took a long time to get invited back.
Yeah, that's my fault. Actually, I think I invited you a couple times and you had conflicts, much like Julio has tonight. You had prior engagements and couldn't make it. So
Well, I'm glad to be here tonight.
I'm glad you could make it. And first time on the show, Ashley McFarland.
Yes, thanks for having me.
Glad to have you guys on. It's gonna be a great show, ladies and gentlemen. We are probably going to spend most of the night talking about the Mueller report. It's the first time that, as it's colloquially known, the Mueller report. I think it's actually got a more official.
It has another
title.
name.
Yeah, an official title, if you read the pages. But we're going to spend most of the time with that. Of course, Dane is a fellow white-collar criminal defense lawyer like myself, and Ashley, in addition to her now life as a white-collar criminal defense lawyer with David Gerger, Sammy Khalil, and Matt Hennessy's firm, she is a former DOJ prosecutor.
I am.
You were here in Southern District on the healthcare fraud task force.
That's right.
And so I think I want to kind of use that because we've seen a lot of task force around the country. We've seen the healthcare fraud task force. We saw the Enron task force years ago. It's always a task force going around. And, I think they're kind of similar to the special counsel investigations. So I want to get your thoughts on that. Obviously, we're gonna delve deep. It's 488 pages. There's no way we're going to cover it all, but this is the first time we've actually got to talk about it in some detail on this show. And I'm glad I could bring on two experienced federal lawyers to talk about it with me. And really what I don't want to do is I don't want to give the misimpression here. Look, we're not political pundits, okay? We're not going to be opining about what Congress's next steps will be. We might guess, but we're in no way political pundits. We're actual practicing lawyers. And so, we're going to give you a view of what it's like from our point of view, okay? What we see every day and how this differs from not just what Dana and I have been doing for years on the private practice, but what Ashley saw on the government side prior to getting into private practice in criminal defense. And there's a lot of things that I think a lot of people don't understand, and there's a lot of misconceptions out there. And hopefully we can clear that up tonight. If you want to get in on the conversation, you can hit us up on Twitter at HCCLA_TV, or you can call into the show. 713-807-1794 is the number. We welcome any and all comments, and even if you have political comments and you want to make your voice known, by all means. We may not be able to address them because, again, we're not political pundits. But let's just jump right into it, guys. I mean, to me, this is not how most criminal investigations are handled in our world.
At all. At all.
It is such an anomaly that, as I remarked recently to some federal prosecutors that I had a case with, and we were trying to negotiate a resolution, and I thought the price point for resolution was way too high. I stopped them and I said, look, guys, I'm just going to be honest with you. The problem that I have in resolving this case with you guys is the public, and what the public is seeing right now, and that includes my client and several other clients, is they see that your price point is way too high compared to what's going on with the special counsel's investigation. That whether or not it's true or not, I'm just telling you what the perception is. The perception that's out there from the media, and I think this report kind of lays out, we were talking a little bit about it before the show, but if you just listen to the media and the media reports, you thought Michael Flynn was a traitor, a treasoner. You thought, Papadopoulos was the same thing. You thought all this stuff, and here these guys are committing these horrific crimes against the country, and they're getting away with slaps on the wrist. I mean, Flynn's plea agreement, when it came out, I talked about it on the show, I'd never seen anything like that. I'd never seen a plea agreement with a agreed guideline range so low.
Well, he hasn't been sentenced yet, right?
Right.
Yeah. And I think initially the judge rejected it.
He did have some hesitation about it.
Yeah.
But I've never seen an agreed guideline range that came out at 0 to 6 months.
Yeah, well, there's a lot of things about this case that are unique and not that we don't see every day. You started with one of them by noting that Ashley was on a task force, and I want to start the show off by disagreeing with you, but you said there were some similarities between a task force and a special prosecutor, and while there are, there's a lot of differences too. So I'd like to spend a little time on the differences there,
Absolutely.
because a task force typically looks at a very big and serious problem and then dedicates resource to it, and they can do a lot of good. A special prosecutor or an independent prosecutor, when there used to be one, don't look at usually a really big problem, but more so specific people, and then they throw their resources at that. And in my experience, which has mostly been observing from here to Washington, is that task force are really good at solving problems, and special prosecutions, to me, tend to result in making more criminals than they find.
Well, sure.
Right? They create them in the process, which is significantly what's happened here, right? People lie in the process, people obstruct, and you end up making more criminals than existed before your investigation started.
How do you feel, Ashley, about the fact that, because I talked to a former agent this week who was just disgusted with the fact that the use of 1001 counts and obstruction of justice to really try and leverage people in such a significant investigation. How do you feel about that, having been a former DOJ prosecutor?
It's interesting that a former agent would say that to you, because when I was a prosecutor, it was often the agents that were trying to get me to charge a 1001 for folks that were, and 1001 for the folks at home as a false statement charge. For anyone that spoke to an FBI agent or a federal agent and misrepresented something or lied or wasn't completely forthcoming about something. And I'll tell you, for a really aggressive prosecutor, you could probably charge almost everyone that talks to an agent or talks to you with a 1001 charge, which is a felony up to 5 years statutory max. And so I think, to me, it happens a lot. I think this is an example of what goes on all around the country all the time, because it's such an easy charge to make. And you're right, it can be used as leverage against folks to maybe cooperate with an investigation. Sometimes it's used to allow folks to plead to a lesser charge when there may be evidence of a greater charge. But it shows you the sheer power that federal prosecutors have, because there are so many charges that can be brought for such, what I think the public would think are little things that someone's doing. I think in this case, in the Mueller investigation, it's hard to know whether there were more egregious charges that they just didn't charge because the individuals were cooperating.
Right, and you know, the U.S. Attorney's Manual says that they're supposed to bring the highest charges possible.
That's right.
And in this case, you know, they didn't do that. I mean, clearly they just, with Flynn and Papadopoulos, they brought menial charges. And we'll never know, I don't think. And I don't think we really get a good explanation of whether or not. I mean, it seems on its face that had Flynn and Papadopoulos just shut the hell up, they would have never gotten charged, right?
I think that's right. I mean, that's the risk you take when you're facing, as all of our clients do, the decision to cooperate or not cooperate. You know, there's this human nature to feel like, well, if I don't cooperate, i.e. if I don't talk, they're going to think I'm guilty. I always tell them they think you're guilty anyway.
Yeah.
And so
you're not going to dissuade them of that notion either.
Right. And so there's cooperate, there's don't cooperate, and then there's the worst option of all, which is cooperate the wrong way, which people did in this case too. That's the worst thing you can do. Get rid of your right to a trial, get rid of your defense, lay down on your sword, and then not reap the benefits of cooperating in the end. But before you get too far off it, you know, you said, you know, a similarity between the cases, you know, this power to charge people with 1001 and obstruction and perjury and things like that. I will tell you, though, in this case, if you look at the number of people who are looked at, or key people who are looked at, and the number of 1001 charges,
that's
you
not
applied
common.
those across the nation to every investigation, we would, 3/4 of us would be in jail, right? I mean,
absolutely.
It would be absurd.
Because the thing is, it's all in the eye of the beholder, right? And all in the eye of the agent of whether or not you lied to them.
Right, and the prosecutor as well. But I'll say this. I think that's what shows the difference in the uniqueness about this particular high-profile investigation and case. There really was nothing like it in history, and I think the pressure and the attention, that's the difference between something like this and like a task force. Because with all the eyes on the special counsel and on this team of prosecutors, they have to produce.
Well, I agree with you on that, but you know, you were on the healthcare fraud task force, which has been a huge problem. I mean,
The task force or healthcare fraud?
well, yeah, the healthcare fraud.
Okay.
I mean, yeah. No, I actually don't think there has been. I mean, I thought there was significant abuses in the Enron task force, but I do not think that the healthcare fraud task force has been abusive. Quite the contrary. I mean, my experience was that you could always have upfront and frank discussions. I mean, and in fact, some of the prosecutors on the task force would come to me at the very front and say, hey, you know, I know we took this charge and you weren't involved in the very beginning. And they were very upfront. You know, we really didn't have a good rapport with the previous lawyer. We think there may be some advice of counsel defense here, but we never really got that far with the other lawyer. Please come talk to us, kind of thing. So I've never really seen any kind of abuses or, you know, games on the healthcare fraud task force. What I will say, though, is I do think that the healthcare fraud task force was really aggressive in going after very high sentences. And was not really willing. So even though they might be willing to talk to you and say, hey, was there a defense here? If you got past that, I mean, we're not giving you a 5-year cap to plead to or anything like that.
Well,
or
right.
1,001
Well,
count.
as you mentioned earlier, the Justice Manual requires prosecutors to go after the highest charge.
Right.
And oftentimes it's healthcare fraud, which is a 10-year stat max, or the healthcare fraud conspiracy, or, you know, money laundering with 20 years.
Yep.
And the sentencing guidelines in those cases,
They're rough.
they're rough because they go according to the loss amounts. And in these healthcare fraud cases, you have multi-million-dollar loss to the
Yes.
Medicare program and to other federal programs. And that's what oftentimes determines the sentences, not necessarily the prosecutors.
Yeah, and I mean, unlike this case, I mean, they could have charged money laundering if they wanted to. They could have charged wire fraud if they wanted to. But they didn't. They chose for Papadopoulos and Flynn to bring the false statement counts right from the beginning.
Well, and I think that may have been a benefit to them.
I agree.
If they had the evidence to charge them with money laundering, a 20-year stat max felony, and they came over early to cooperate and to be forthcoming, then a 5-year cap with a 1,001 seems like a great deal.
It's really hard because we don't know the whole story, right? I mean, we got a lot of redactions in here for obvious reasons. I mean, and that's what drives me so freaking crazy is we need to see the whole report. Well,
Right.
wait a second. There's still an active grand jury investigation
Right.
going on. You've still got Roger Stone, who, like him or not, he's still got a right to a fair trial. You know, and if you disclose the whole thing, it's not hard to figure out where in the report Roger Stone is. You know, I mean, when you start looking down the names, it's blacked out ongoing matter. I mean, it would be prejudicial to him. And as a defense attorney, the last thing I would want is this report coming out when my client still has the right to a fair and impartial jury trial.
Right.
The redaction issue should be non-controversial.
Exactly.
I mean, the buckets of information that are redacted in there are kind of par for the course, right?
Right.
Grand jury materials, which we never get to see. Right?
No.
And you know, personal information and ongoing investigations. So that's just, I mean, those are statutes, not even just policy that really shouldn't be controversial. The interesting thing to me, though, about DOJ policy and kind of the content and release of the report is this comment by Mueller that, you know, he did not exonerate the president after many, many pages of specific instances that could be read to be damning.
Sure.
Right? Because there's a DOJ policy to not publicly accuse someone who you're not going to indict. I kind of have a question here about whether that DOJ policy was followed or whether it was seen as not applicable or knowingly disregarded.
But don't you think, I mean, I had a prosecutor, the story I was telling you about how I was trying to negotiate, and one of the responses was that I got from a local prosecutor here was, well, it's different when you're providing information about the President of the United States. You tend to get better deals when it's a matter of national security. And I was like, okay, I get that. I understand your point. But at the same time, I'm thinking in the back of my mind, yeah, but in some regards, is it that and I'm not trying to be a defender of everything the president has done or, validate what he has said in any way at all. But you have to, in some regards, look at it and honestly take a look at whether or not this was an investigation that was funneled in one direction, and that was to try and get the president. And at the end of the day, what do we have? We have this. And it's almost as if they hit kind of not a brick wall, but, a wall that they really couldn't get past.
I don't think there's any question that the goal of this investigation was to find something on Trump and the Trump campaign.
Right.
I mean, it was all but set out in the
title.
Right. I think that's pretty remarkable, right? I don't know that many people and companies and organizations that could undergo a 2-year microscope of 2,800 subpoenas and 500 interviews and $30 million and come up just squeaky clean, which as to Russian, if not collusion, conspiracy, whatever you want to call it, wasn't there. And
well, wait a minute. I don't think anybody came out of this squeaky clean.
No.
And in fact, I think there was clear evidence that Russia interfered in our elections. I mean, that is widely accepted in all the law enforcement communities.
Yeah.
And also kind of known before the investigation started.
That's right. Well, that's what initiated the investigation. So I don't think it was necessarily started to get President Trump, but there was evidence that Russia interfered in our elections to support candidate Trump. And there was a question and some evidence about whether there was some coordination or an agreement between the campaign and the Russians to do that. I think the investigation then turned towards President Trump once there were actions by him to interfere with the special counsel or interfere with their obstructions investigation.
Yeah, I mean, they did start to. I mean, you've got, of course, the situation where he's alleged to have told White House counsel to fire the special counsel and then lie about what I told you to do. So yeah, I mean, look, I agree with you. I don't think he comes off squeaky clean at all.
And not to mention the fact that they said, I mean, I think there was a clear distinction, right? On the Volume 1 dealing with the conspiracy with Russians, they said they found no evidence of, or they did not find sufficient evidence of a conspiracy.
Correct.
Right? Second part of the report that dealt with the obstruction, they said, if we had found that there was not sufficient evidence, we would have said that.
So, yeah.
They didn't say that.
Yeah, that's right. And in fact, I've got it pulled up right here. They.
And the only reason that they didn't conclude that that the president did not obstruct justice was because they couldn't accuse him of a crime, given that he's a sitting president.
This was one of the paragraphs that I had marked. The concerns about the fairness of such a determination would be heightened in the case of a sitting president, and this is, of course, regarding whether or not there was obstruction of justice, and they talk about citing to as what constitutes a federal offense of a sitting president, where a federal prosecutor's accusation of a crime, even in an internal report, could carry consequences that extend beyond the realm of criminal justice. They talk about the difficulty of preserving a sealed indictment, that it would likely get out and harm the presidency and the president's term and the stigma that could come with it. you know, they talked about how the fact that to accuse a president of a crime, essentially, in this manner where they could not bring an indictment and allow him to
Clear his name.
clear his name through the court systems, through the right to a speedy trial, through the right to confront and compel, you know, confront witnesses and compel witnesses on his behalf. That's where they went in that analysis on this.
Well, look, I mean, that's not a foreign concept, right? It's got
Right.
a name, it's due process, it's in the Constitution. So, I mean, that is, and that's the DOJ policy that I referred to before. I mean, the par for the course is you do not publicly accuse an individual who you're not going to charge with a crime.
Yeah.
I don't know of an exception letting the special counsel off the hook for that. So in my view, it's kind of a remarkable statement to say, hey, by the way, had we found anything exonerating him, we would have let you know, and we didn't find any. Because to me, your job, right, Robert Mueller's a prosecutor. Prosecutor's job is to bring charges or decline charges. And it really stops there, to me. So once they decided internally, if that's what they determined, that you can't charge the president, why list all of these instances and then say, we haven't exonerated?
Here's why I think, and we have to keep this in the context that this is a very special circumstance.
Right.
And I think they talked about the fact that public interests weighed in favor of them outlining this. But not only that, this whole report is an outline for Congress.
Absolutely.
I think they wanted to outline the steps they went through, the evidence that they gathered, because they didn't want to preempt the constitutional process for impeachment. They said, okay, we'll just let you know exactly what we did, how we did it, and what we have, so that Congress can do their job. And because there is no other instance other than a sitting president where this would be relevant, I think they had to go to extraordinary measures that usually, you're right, a prosecutor would never do that, would never say, oh, we would let you know if we can exonerate him, but we can't. But I think because this is involving a sitting president of the United States, it had to be a very unique circumstance.
Yeah, and I think the other thing too, we were talking before we went on the show about, you know, whether or not this concept of whether or not a president could even obstruct justice in this context. You know, I mean, does he have the right to make these statements?
You mean about the public statements that he made up
Correct.
to Cohen and to
Yes.
Flynn?
Right, or even going a step further, the statements that he makes to White House counsel. You know, I mean, he is the chief executive, right? And in his role as the chief executive, correct me if I'm wrong, but he is the head of the Department of Justice.
I don't know, what do you think?
Well, I think that goes to motive, right?
It does.
It goes to motive. Yes, I think a president can obstruct justice. Yes, I think that public statements, just because they're public, doesn't mean that they aren't also satisfying the elements of obstruction of justice. It's all about your intent. And if there was a corrupt intent to interfere with an investigation, whether it be, you know, a congressional hearing or a FBI investigation, I think that would be obstruction. There's a reason why there's a separation of the three branches of government here.
Yeah.
There's a reason why his counsel advised him, do not talk to DOJ about this investigation. So I think so.
Yeah, I don't think there's any question that a president can obstruct, right? I mean, I think if President Trump was being investigated for something and there was evidence on his cell phone and he, you know, burned it, you know, that'd be obstruction. But in this context, I have real questions about the types of things that were listed in the Mueller report. There are a number of problems there. One is a lot of them have to do with his constitutional executive authority, right? At the end of the day, whether you agree with it or disagree with it, you know, people in the executive branch, which includes the Justice Department, which includes even Mueller, they report to him.
Yeah.
And so, you know, I would worry about the precedent of going after people for doing things that you think their motive was bad, but they actually have the authority, the absolute authority to do. Yeah, and then you have other issues like, you know, he didn't sit down and talk to him, which I think was one of his unquestionably wise things.
Yeah. But think about it this way. I mean, you know, your boss has the authority to fire you. But if their motive in firing you is because they don't like you because you're a woman or you're a man or you're whatever. That's their motive. That's behind their action. They had the authority to fire you, but it's illegal to do that for certain bases.
Yeah,
I
Well,
agree.
The other problem, though, is that the statute requires corrupt intent, and a lot of what he did, he either did in public or he did in private, and then told the public that he did it. And
Yeah, he
so
wasn't hiding it.
it's hard to do things. This is my own personal theory here. It's hard to act corruptly in a public way, right?
I
And
tend to
there are
agree with you
actually
with that.
statutes like the bribery statutes that require corrupt intent that my theory is they cannot be violated unless done secretly, right? Because there's like a bribery statute that on its face would apply to like you tipping a waiter to get better service. Well, what makes it corrupt? Well, it's when you do it secretly
Yeah.
behind, right? It's the only way to draw a distinction. So it's hard for me to accept that somebody that does things out in the open is acting corruptly.
Let's take your example. You said if he had someone has evidence on their phone that incriminates them, right? And they're in front of a TV camera like this one, and they bring their phone, and they have some pretenses as to why they're going to destroy their phone on camera for whatever reasons. Let's say they wanted to make a point, but their motive and their intent is, I got to get rid of this evidence that's on my phone. They did that in public. They destroyed their phone in public. But if their motive and intent is to destroy evidence in an investigation,
Yeah, I think the difference in your example is that destroying it publicly would still destroy the information on the phone, whereas what he was doing to try to get someone, fire someone so that they wouldn't do something, or wave a carrot in front of somebody, a pardon to get them to act a certain way. Once that becomes public, right, there's no deceit there, there's no trickery about what the person is doing and why they're doing it. So I think it's a little different than the public.
I get that, but there's the element of obstruction. There's no element that requires it to be done in secret. It's just all about whether your intent.
Yeah, and it's a subjective question.
It,
for a
it,
jury to
honestly,
decide.
I think it's hard. I
It
think
is.
it's a really difficult question because of the same points that you're making right now. I think it's really hard to get into the mind of anyone.
I think it's a lot easier in your example to sit back if you were 12 people just watching. Okay, if you were 12 people sitting over here on the other side of the studio, and you took your cell phone out and destroyed it, and you were just making statements. I think it'd be a lot easier if I'm on that jury. To me, it's a lot easier to say, well, her actions were clearly an intent to destroy something versus, well, what really was his intent? I mean,
Yeah.
he's not hiding it from us. He's being pretty open and notorious about it. It's a much tougher call, I think. It's a factual determination, which is why we have jury trials in this country.
Yeah. Well, and
to
it makes it
determine
even
that
more
stuff.
complicated because of he's the president.
Yeah.
He makes public statements all the time. Like that's his job.
But remember, our governor got indicted for essentially making public statements that the Court of Appeals here eventually ruled that he had a First Amendment right to do so. It was political speech, essentially. Right. And I wonder if some of these statements that he's made could potentially fall under that kind of protection. I mean, he is the chief executive after all.
Well, I think that's why it says in the Mueller report that even without the Office of Legal Counsel opinion saying that you can't indict a sitting president, there's still going to be issues with the evidence.
Yep.
These are still difficult questions. There are still defenses. But I think, why go through the analysis that they went through about whether they could keep an indictment sealed or not, or whether these other instances would get out to the public? Why go through that if they did not think they had enough to actually indict?
Well, I mean, I think they kind of had to justify their oxygen too.
Yeah.
Right?
Well, I personally think the real answer is because there was a political motive to it, and I think
Yeah.
they did want to give it to Congress and let Congress do what it thought it should, and I think what it thought it should do is impeach him. Because really, everything you've said I agree with, but if you're going to make that conclusion, why not just have one paragraph of Volume 2 that says, we've decided that we can't charge a sitting president, and even if we could, there are issues with executive authority and the interplay between that and the obstruction statute.
Yeah, and
Why then
Well,
go through everything
I
after
think,
that?
well, one, because obviously Congress and impeachment, but two,
But that's the special counsel's mission is not to lay a roadmap for an impeachment process for Congress. They have their own investigative
Well,
authority.
but there's the other thing that they mentioned in the report is that they wanted to preserve the evidence, because they believe that a sitting president can be indicted once they're no longer president. And so if they think that there's sufficient evidence to indict, but they just can't, then they wanted to preserve the evidence that they gathered during the investigation, such that whoever down the line will take it up then.
do you guys think, for a long-standing history in this country, we saw with Nixon, since Nixon left and Ford pardoned him, there was just kind of this overall sense of, the country, yes, this was a bad episode, the country needs to move on with it. When Clinton went through his impeachment, the Senate refused to convict him, and, it kind of went by the wayside. I think since Clinton, we've seen other countries who have not shied away from charging their leaders with criminal acts, whereas the United States has been reticent to do so. Do you think we are kind of coming to a point where we may actually consider that, even once he leaves office, for crimes that he committed while in office?
I hope not. So for as long as I've been old enough to really follow and care about politics, all I can say is that if we change that rule, it seems the political state of our country is that every president is going to be facing charges, right?
Yeah.
It was going to be President Bush for weapons of mass destruction and war crimes, and President Clinton for whatever it started as and ended with Monica Lewinsky, and but there were other things surrounding that presidency, and now it's bled over to President Trump. So it's not something I want to deal with every presidential term.
It seems like it'd be a bad precedent, because when you read the Mueller report, one of the takeaways I took from it was, well, crap, Obama sure knew this was going on. He didn't do anything about it.
Obama knew what was going on.
The interference in the election. Theoretically, him knowing about, a national security breach and not doing anything about it, could that, I'm sure you could find a crime somewhere for, at least misprision of a felony. Again, it goes back to the fact that in the over 300,000 crimes that we have between Title 18, Title 8, Title 21, the CFRs, we're probably violating at least one of them right now being on this show.
Weren't there sanctions though?
There were. But my point is that it sets a dangerous precedent potentially, because as you alluded to with Bush and the weapons of mass destruction, what does a president know? When does he know it? And what actions does he take? You could probably charge every CIA agent and every FBI agent with obstruction of justice for failing to turn in a report on something. I just think I agree with you, Dane. It potentially sets a bad precedent, because we've always said that our country is one that just, look, we recognize the bad behavior, but we as a country just need to kind of set it aside and move on. But I kind of feel that the tide may be changing a little bit on that.
Well, we didn't set it aside and move on with Nixon. He resigned ultimately, but that's because I think everything was falling around him. Now, I'm not comparing Nixon to Trump and the allegations.
Some pretty similarities.
Here. But I think we're a country of laws, and no one is exempt in this country. And I think that's one of the things that makes this country great, is that while we have lots of issues with our legal system, it applies to everyone. And so I do see the issues of we don't want this process to be corrupted in any way by political gain. We certainly don't want that. We don't want every tit for tat being a basis for criminal charges against the president. No one has the appetite for that. But at the same time, there has to be a line drawn where even the president of the United States is accountable to the laws of this country. Now, I really respect, actually, the conclusion that the Mueller team reached here in not finding or saying because they could not indict this president that they're not going to just put it out there just for political folly, and that they respected the due process and the Constitution here. I think that's a testament to our system in this country. But to say in the future that, there would not be conduct that would, I think we would revisit that.
Yeah.
I can't say that a president should always be above the law, even while they're in office.
Yeah, I mean, I agree with you on that. I mean, everybody seems to hate him so much. Is the thing.
Not everybody. I mean,
no, I agree. He's probably still hovering around 50% at least approval rating at this point. And Lord knows, with as many people as seem to be wanting to jump in the Democratic primary, his poll numbers may go up. Who knows?
So are we better off with the Mueller report than we were when we started?
I'm not sure. I think in our world, I think it has caused problems because I think you are seeing even more of this notion, this divide of rich versus poor justice. And I think this has kind of exacerbated that. You made the statement that nobody is above the law and everybody is subject to it. But there just seems to be this huge groundswell that is really coming up in this country right now that, the disparity between rich and poor in the justice system is that not everybody is treated the same.
But that's true.
Well, it is and it isn't. I think what's left out is people think that, white collar defendants who have money get these slaps on the wrist, i.e. what Flynn gets. And these are the kind of cases that get all the publicity, right? Like what's going on with the college admissions scandal. I mean, these people are pleading early and, getting 4 to 6 month recommendations or 15 to 21. And I know you can't talk about it because
neither can she.
Yeah.
But true. But I mean, and I'm not going to ask you to comment on those. But I think that those are the cases that get the high publicity and get the most attention. People tend to forget that Jeff Skilling got 20 years in prison to start. People tend to forget Jamie Olis got 24 years in prison. People forget that.
Or some of these healthcare fraud defendants.
Right.
There was a sentence,
Just
a couple of years ago for 75 years.
Yes.
80 years.
Yes, that Alan Stanford got 100 years in prison. Bernie Madoff got 150 years in prison. So I just feel like the notion that white-collar defendants are somehow sentenced more lightly in this country because they have the means to afford lawyers or they have the means to pay restitution. I think at the state level, yes, that more often than not can be the case. But it completely ignores what happens at the federal level, where more often than not, I believe, white-collar defendants almost get disproportionately higher sentences than some people. And I'm talking about, and I don't want to get into I don't think it matters what the race is. I'm just talking about that I have seen a lot of judges who are much harsher in white-collar financial crime cases than, say, a drug conspiracy case.
I've seen the opposite.
Yeah.
I've seen the opposite. And I don't know what the data is. I'm sure we can look at the statistics on the Fifth Circuit or the other sentencing commission statistics about that. But I have seen cases when I was a prosecutor where judges could relate to white-collar defendants. They could see them as themselves or their neighbor or a friend. And I've had judges actually say on the record that to a person like that, a federal sentence, jail time, they take it harder.
It's the collateral consequence.
Yeah. Which, that can be debated. But I do think there is a misconception out there. I don't know the data, but I do think that if you look broad at all of the cases in the country that are not non-white collar cases and whether those folks get greater sentences. I mean, we're talking about a woman that registered her child using a wrong address
Yeah.
to get their child in a better school district and sentenced to 5 years
Yep.
for something like that. She wasn't rich. She was black. I mean, so you
And
can't
that was
tell
a state crime.
That was a state crime,
And
right?
I think the disparity, and that's what I'm trying to, the state system, I do think, has the huge disparity, and does not really account for, what we're talking about. I think that the state system is completely jacked up. There is a huge disparity between those who can afford counsel and those who can't.
Why do you think that is? Why do you think there's a difference between the state and the federal?
The guidelines. I think the guidelines have a lot to play with it because, one, I think there's the guidelines that come into play. The fact that you don't have parole in the federal system, so you're doing 85% of the sentence. I think the fact that what the U.S. Attorney's Manual, as you say, sets forth, we are to charge the highest offense, and we are to ask for the highest sentence possible. I think those kind of things are what drive it on the federal side. Plus, they don't take every case, and so on the state side, you're trying to move cases, and in moving a case, if you've got a defendant who can come up with a substantial portion of the restitution, somebody who has the means to do so, I think it's a lot easier for a prosecutor to give in and say, yeah, I'll give them deferred adjudication, no jail time. And they can come up with, okay, they stole $100,000, they can pay back 50 of it to start and pay back the rest over time. Yeah, let's put them on a 10-year deferred and let them go down the road. And the judges don't really have a problem with it, because again, the state system is so overloaded, they're trying to move cases. And so I think that, and unlike the federal system, I don't think the resources are there to really properly, I think a lot of state court prosecutors, they don't want to touch white collar crime. It's a lot of paperwork. We don't want to get into that.
Yeah. Well, look, I agree with everything you guys said. The only thing I would add to it for your listeners is, I think a way to consider looking at it, at least, I won't tell them to look at it like this, is it's not that, rich or white collar or white or whatever category you want to put people in the white collar arena are getting treated too leniently. It's that everybody else is getting treated too harshly or unfairly.
Right.
So, and I'm not saying I'm certain of that, but it's just another perspective to have, right? Which is, this is what happens when you have the means to put up an appropriate defense, to get good counsel. Sometimes you have the educational background to, almost aid in your own defense and think through the process. Where a lot of people in a lot of different contexts don't have that. They should. Right, and that's what leads to, you hear these stories where, Manafort gets 4 years and a kid that stole a pair of sneakers, right, in Louisiana got 15 years. Okay, well, what's wrong there is not Manafort getting 4 years.
Yeah, it's
right?
the kid getting
It's
the
the kid getting 15 years,
Yeah.
right? So let's not find ways to put Manafort in for, to make sure he dies in prison.
Right.
Let's try to fix the other problem.
And I agree with you, Dane, on that. But the problem is that until we fix that system, there are people who are getting disproportionately
Absolutely.
punished and imprisoned. And so, what do you do in the stopgap? Does that kid keep getting 15 years?
I know.
While everyone else? And I agree. Like I'm a white collar defense attorney.
Yeah.
I certainly don't want my clients to get
They
high
should
sentences.
be more harsh. Yeah.
Yeah,
They
but
should be more harshly punished.
no, I wouldn't say that. I don't want anyone to be more harshly punished. But there's something needs to happen. We can't just keep saying this as if it's just the way it is, where people are spending their lives in prison unfairly too long.
Here's an idea. $30 million for a special prosecution, maybe more public defenders.
Well, the interesting thing, so I take appointments on the federal side. I've been on the CJA panel for a long time, and I mean, I got into a debate with somebody the other day about whether or not do you try your hardest on the cases that you're appointed on versus the cases that you're retained on. And my point was, I give the same effort whether or not I'm appointed on a case
Absolutely.
or whether or not I'm retained on a case. The guy that pays me a large sum of money versus the person who I'm getting paid.
You don't work hard on either of those.
Yeah. No, I mean, because for me, and I'm not saying every lawyer is like this, but I feel like as the lawyer, you should have enough pride in yourself that if you're going to take that court-appointed case, it's a reflection of you at the end of the day. You have to go up and make the arguments in front of the judge. You're the one who has to try the case. And if you don't have enough pride in yourself to say, I'm going to give it my all because this is my reputation on the line, this is how I perform, then, and you just don't have this innate, my job is to help somebody.
Yeah, and as a criminal defense attorney,
Yes.
we're not talking about money here. We're
Right.
not talking about contracts between businesses.
Correct.
I mean, we are all that's as criminal defense lawyers, we are what stand between our clients and their livelihood, their liberty,
Yeah.
whether they're paying client or not.
Well, and I'll give you a great example. I had a case, a healthcare fraud case that I was appointed to 2.5 years ago, and worked my butt off on the case. And, she was charged in a 29 count indictment plus a money laundering count and everything else. At the end of the day, we got really close to trial. And I convinced the prosecutor to dismiss the indictment and let her plead to an information on a tax count for filing one false tax return
Good for you.
in 2012. And you know what she got? She got probation in federal court.
That's a great result.
Now, she was a young black female, and she wasn't treated any differently, I don't think, than anybody else. I mean, I gave her the best representation possible. We got an outstanding result. And the judge, didn't sentence her to jail time for it. And I think if you don't have enough pride in yourself to make a fight like that for somebody, don't take the case. Don't sign up for the panel. Don't go represent those people. If you're not willing to fight as hard for the people that you get appointed on as the people that you retain for, that's where the problem lies. Okay. And I know plenty of lawyers, David Adler, all these guys who are straddle the line between both court-appointed and retained work, and they do hella jobs for their clients.
Yeah.
And so I just think I think you can take this report and just kind of throw it out the window in terms of how the normal federal case operates. It's just that's not how it works every day for us and our clients. It's just not.
That's right.
We don't get the benefit of a 488-page report,
Yeah. Well,
we get
no question.
what we get. And sometimes we don't get it all.
Yeah, but our clients typically also don't have to suffer through a special investigation that is dedicated at them. So
leaks are coming out
I
in the
guess
press.
it's just my point is,
But
it cuts both ways, and it may
Right.
cut one way harder than the other. But
Well, it's all about perspective, right? I mean, you're the president of the United States, as kind of to paraphrase Puff Daddy and Biggie Smalls, more money, more problems. I mean, you get up to that level, you're asking
Target
for
on
more
you.
problems. You could get a target on your back versus, but when you are an individual and you have the Department of Justice coming after you, even on a regular prosecution, it sure feels like a special prosecutor's coming after you.
Okay, we have to, there's kind of an element here though. President Trump didn't make it easier on himself.
No, he did not. But you
I
know
mean,
what?
there were,
A lot of our clients don't make it easier on themselves either. Sometimes some of them don't follow all the
rarely
rules.
makes it.
Yeah.
I will.
would be a
I will
client
say
control
this.
nightmare.
I think. Well, first, let me ask: it may be a crime to suggest showing empathy to Donald Trump?
You might get flogged and stoned in the streets.
So I may, because
Yeah.
I'm no supporter either. But here's the empathy that I have for him. To endure a 3-year or 2-year investigation of that magnitude, when what you've been saying from day one is, I didn't conspire with Russia, I don't think anybody from my campaign did, and basically everybody calls BS, right? The thing I empathize with is I think most people would have a desire to do everything they thought they could legally do to let that side of the story and to tell their story come out and to right that ship. So I kind of get that, like some of these things that he did, I at least from a human nature perspective can understand him trying to do.
I gotta give you a hard time, Dane, because
I like hard
Because-
times.
yes, as a
bring it on.
normal Joe down the street, yeah, you're gonna call your friend and try to figure out way. He is the president of the United States. That means something. You are no longer just Donald Trump. You represent our entire country. People that voted for you, people that didn't vote for you. You represent 200 plus years of history here. I mean, he has to be held to a higher standard.
And all I'm saying is that all of those things are true, and he happened to be being accused of treason. So I'm saying I get
It's
the
a
desire to fight back.
There were allegations, there was evidence that needed to be followed up on. An investigation did that. They concluded that there was no evidence of conspiracy. They did not conclude that there was no evidence of obstruction. So
Right.
I think, no one forced him to run for president. No one forced any of this on him. This is par for the course here.
Sure.
And while I have a lot of empathy for a lot of people,
He's not one of them.
not in this circumstance. Not in this circumstance, because one, he's still free. He's a free man with the powers of the president. He is not being charged, at least right now. He is still running for re-election. He hasn't given up. He seems to like the job. He wants another round at it. I just think I'm not sorry for Donald Trump. I think that we owe it to the people of this country to figure out what was going on, to investigate it, and to spend the resources. $30 million in the big scheme of things is not a ton of money for this country.
No, it's not. I think more, the hard part for me is, he doesn't have, as this report said, he doesn't have the right to a speedy trial. He doesn't have the right to compel and confront witnesses and go through the normal process. So what is he left with? He kind of has to get on Twitter and get on the media and mount his defense that way, right? And the hard part is, to me, what if they do charge him after he gets out? Is he really going to get a fair trial? I mean,
What
it's
are
hard.
the odds of that actually happening? I don't think.
Right,
I don't think that's going to happen.
I don't think so. I don't think it should
Yeah.
happen.
Yeah,
but
I
there's
don't
a
think
lot
it's
of
going to.
people who think he should be, that the state of New York should go after him, or that he should be charged after he gets out. I do think that there should be, if he was impeached, or if he loses the election, whichever comes first, if that's the route they decide to go or whatever based on this stuff. And I'm not saying they should or they shouldn't. I'm not making any judgment anyway. But I just kind of feel like if we go down that route of impeachment, or let's say he's defeating the election, I just kind of think we should take an almost Nixon Ford approach where it's like just going down the road,
We said we weren't going to take a political stance, and I feel like we've gotten pretty political.
I know. It just
But
feels
so
like it
here's
leads
the
to that.
But here's the ironic thing about, and the reason why I ask you the question: are we better off with the Mueller report than we were before? So we think there's meddling by the Russians in our election, right? And the
I
purpose
don't
of
think
that.
we know. There's evidence of that. We know.
No, I meant at the time
Okay.
the
Yeah.
investigation was started, it was because we thought there was meddling by the Russians
Okay.
in our elections. And their intent in that, we thought, and we've learned, was to create political discord in the country to meddle with those elections. The Mueller report, right? Did it solve that underlying political discord, all right?
No.
Political chaos?
Well, that's-
I mean, it's just ironic to me. I'm not saying it's right or wrong. It's political discord, meddling, investigation. There's no crime there with the meddling as far as the Trump campaign is concerned, and now more discord.
Well, no, but
And 15 new felons that didn't exist before the investigation started.
But what you're hitting on is that we have learned, they have shown, it has been proven from the evidence, well, not proven, there's been a trial, but Russians did interfere in our elections.
I guess I just
What are we
always
going to
assumed
do?
that.
But what are we going to do about that?
Well, I
A
think that's the
foreign
scary-
power
yeah.
interfered in our elections.
I mean,
what is the President of the United States going to do about that?
I think
See,
that's
I didn't
the.
need a special prosecutor to tell me that.
You
I mean,
didn't.
I thought I assumed there was meddling in the election by
Well,
the
just
Russians.
like we meddle in other people's elections.
So
I think the U.S. meddles in every election.
So do
that
we
it
just let
thinks
that
it
go?
should.
Do we
I'm
just
not-
let it go?
No, I don't think we should let it go. I think where I don't think we're better off because of this is even if you look at the president, what it says about the president and everything else, how do we get to the point where our national security is so vulnerable? You know, I mean, how have we gotten to the point that people can come in through Facebook, through Twitter, and sow this kind of discord amongst Americans, you know, and use it against us and turn it against us? And
Well, let's not be. I think we need to be clear here. The Russians didn't sow discord. There's already discord.
true.
They may have taken advantage of what's already there,
Yeah.
and tried to sort of put a spotlight on some things that's already there. We have issues that we're
Well,
not really dealing with.
Yeah, and I think but you know, to be fair, that's what we've done in other countries. You go in and you incite.
I'm staying far away from that.
You incite riots. You know, you incite the other side to come out. I mean, so I think yes. I mean, did they do anything that our country hasn't done? No, of course not. But should we be concerned about it? Yes, absolutely. And the question is, what are we going to do about it?
I think. Well, I'll let you finish.
Well, no. I mean, I'm not sure that I want to know.
I
why
don't
do we
either.
wanna why do we want to
That's why I said
publicly
I assumed
put out our
the
plan?
problem, and I assume a solution will come from actions I don't know about,
And
whether or
shouldn't
not
know
there was
about.
a Mueller report,
Yeah.
right? I mean, I don't. That's what I meant when I said I don't need a special prosecutor to say there was meddling and it's serious.
Yeah.
And by the way, most people that care about the Mueller report really didn't care about the Russian meddling, as evidenced by the main focus now being that meddling was found, but Trump campaign wasn't involved. It's all about obstruction now, right?
Yeah.
So, I mean, that shows really, I think, to most people, it really is political.
Yeah.
And now that there's no Trump conspiracy with the Russians, the Mueller report's key finding is on obstruction.
But-
I mean, that's most of what I'm hearing from people.
My big takeaway that people should have, because we only have 30 seconds left. I know you thought this would last an eternity. We are in the last 30 seconds. That I think is, just shut the hell up when the FBI or any kind of law enforcement has gone to you. It's
Hey,
really that simple.
Yes, people. If there's anything that they can take away from this discussion, if an agent comes to your doorstep, you do not have to talk to them. You do not have to talk to them.
She just said it's
Go
obstruction.
get a lawyer.
Obstruction.
No, you have the right to an attorney, and I think a lot of people are intimidated when they show up. You have a right to an attorney. So just say, can I have your card? I'll call you back when I talk to my attorney.
When they come to talk to you or execute a search warrant, it's not a subpoena to appear. You're not being put in front of a grand jury. It's not a court order saying, testify now.
And
Shut up.
And you're not going to talk your way out of it.
I know.
That's
you're
right.
not going to talk your way out of it.
Not
You
right
might
away.
talk your way into it.
You'll definitely talk your way into it.
Not going to talk your way out of it.
Yeah. So, what'd you think first time?
Fun.
Yeah. See,
Yeah.
you're all
You should
worried.
have me back.
We intend to. I mean, see, you were all worried about an hour with no break.
An hour time. Yeah. No, that was fun.
So now I've made it where you want to come back. Now you're excited. You're like,
Yeah.
wait, let's go another hour.
Yeah.
I want more of Dane Ball.
Day was great.
It's a fun conversation.
It was fun.
It's a fun conversation. We need to do it again. That's all the time we have for tonight, ladies and gentlemen. I want to thank my guests, Dane Ball and Ashley McFarland, for joining me. If you have any comments that you want to leave, go to our Twitter page at HCCLA_TV. You can also go to our Facebook page for HCCLA and leave a comment there. I think we're going to have to talk about this. I think the Reasonable Doubt Facebook page is down right now. So leave a comment on the HCCLA Facebook page. But that's all the time we have for this week. I apologize for my co-host and his prior commitments, but hopefully he'll be back next week or the week after that, or whenever he decides this show is important to him again. So good night, everybody. We'll see you next time.